Today at the National Press Club, the Federal Attorney General, Christian Porter. He'll discuss getting the right balance from religious freedoms to integrity commission and in between. Christian Porter with today's National Press Club address.
Good afternoon, ladies and gentlemen, and welcome to the National Press Club of Australia, today's Westpac address. My name is Sarah Lane. I am the Vice President and presenter of the Radio Current Affairs program. Today's guest is the Attorney General and the Leader of the House, Christian Porter, in his first speech here at the club as if you're applying conversation on John's computer, our username is @pressclubaust. You can also use the hashtag. Everybody, please join me in welcoming Christian Porter.
Well, thank you, Sabra, for that introduction, short and sweet. I'd much rather short introductions than those introductions that give you some kind of false hope. I was recently introduced by the Prime Minister in a way that gave me cruel false hope of praise. You'll all be familiar with Prime Ministers doing that roll call of their cabinet, and he came to introduce me and he said that I was the best lawyer in, and for a soaring microsecond before the actual word was substituted, I was revelling in this potential praise, Best lawyer in criminal justice, the state, the possibilities were endless. And then came the crashing words, Christian Porter is the best lawyer in Parliament. Not necessarily every lawyer's dream, and even when I thought about it, it's probably not true, so it was all very awkward. Thank you, though, very much to the National Press Club for the opportunity to speak, and I'd like to acknowledge the traditional owners on the land on which we stand and pay my respect to their elders past and present. I'd like to start with a story that I've always really liked, which is a story about a great argument between a scientist and a social scientist in the 1970s, and they reached an interesting stalemate when a mathematician challenged an economist to name one single proposition in the entirety of the social sciences that was both observably true and non-trivial. The idea being that if you couldn't do that, surely you couldn't lay any claim to being a scientist by way of social science. And the mathematician was a fellow by the name of Stanislaw Ulam, who was a nuclear physicist on the Manhattan Project, and the economist, a giant figure, Paul Samuelson. And it actually took Samuelson several years to come up with a response, but he nailed it eventually when he came up with David Ricardo's theory of the comparative advantage of trade, which is in the social sciences, it's demonstrably true and it's far from trivial. I mean, world economic growth's been built on it for decades now. And it occurs to me in being asked to speak here today that there's probably one other theory in the social sciences that is both demonstrably true and non-trivial, and that is a theory from the world of ethics or values or rights, whatever label you want to put on them, that says that human rights are in a constant state of conflict. And if it is true that in practice rights and values kind of clash with each other and inescapably make conflicting demands on governments, then that is, I think, an observable truth in the social sciences, which is completely non-trivial because it has profound implications. It at least tends to argue in favour of democratic resolution processes and compromises. But I must say that whether or not that is demonstrably true, every single task I seem to get allotted in this portfolio says that it is demonstrably true. Every issue or task or piece of legislation that I come to draft inevitably supports that observation that in practice, human rights tend to collide with each other rather than neatly contouring into each other. And the Religious Discrimination Bill, which I want to speak on a little bit at the commencement of this speech, I think clearly demonstrates this concept of rights colliding and conflicting rather than contouring. That bill was released in draft form on 29 August. I have personally consulted in 2-hour sessions with over 90 different stakeholders, everything from religious groups and unions to the LGBTI community and business. And one thing is perfectly clear, and that is that people will disagree on which rights are more important than others and where to draw the line between rights. That is one thing I've taken away solidly from that process. And the consultation's been very constructive, but it always seems to inevitably end at a point where it's just factually obvious that these rights and freedoms collide. The unavoidable fact is if the colliding nature of rights means that there's simply no way to exhaustively define rights boundaries with each other in a way that sees them perfectly contour and sees everyone agree, then there is obvious examples about processes where you have to try and draw those balancing lines. And in the context of the Religious Discrimination Bill, one of those interesting areas has been with respect to freedoms to associate. So whether it's on the basis of gender or religion or age, that freedom to associate is a really fundamental freedom in our society, and it always needs to be balanced against the right that we seek to protect in discrimination legislation, which is essentially the right for individuals to access places, institutions, and be free from the arbitrary exclusion of others in that process. And as I've been drafting the Religious Discrimination Bill, there's been one example that has stuck in my head throughout the drafting process. And that was with respect to an incident last year where the CEO of the New South Wales Jewish Board of Deputies was refused entry to a function at New South Wales State Parliament House because of the religiosity of his position. Now, the Labor Deputy Leader of the New South Wales Upper House, to his great credit, properly and swiftly said that Mr. Aladef had an official invitation to be at the function, that he was welcome to attend, and it was, in his words, stupid, malicious and vindictive to refuse him entry into a multicultural event. Now, I think we'd all agree with that proposition, but that exclusionary conduct was clearly malicious, it was vindictive, but one of the reasons why a bill like this is important is that in New South Wales, without the type of proposed legislation that we are now working on, there would actually be no avenue for Mr. Alderhef to argue that what happened was unlawful discrimination on the basis of his religion. He just simply couldn't do that because there was no law that said it was unlawful discrimination. And in a structural sense, the 4 existing Commonwealth Discrimination Acts, which deal with race, sex, disability and age, actually give expression to the most traditional conception of liberal democratic rights, in the negative rights sense, that laws should protect us from others infringing on our natural rights as far as it is reasonable. And in the case of Mr. Aladef, a complaint, I think, would have been a very powerful avenue to argue the treatment was unlawful discrimination on the basis of his religion, and further, such a complaint would have potentially been a very powerful general deterrence, which may have also shed light on anti-Semitism. But then, of course, in enshrining a right like that, you always have to balance that right against other rights, and in anti-discrimination legislation, you've got to be very careful with clauses so that they don't interfere too heavily with freedom of expression or freedom of association. And a very particular issue that arises in the context of religious discrimination bills is freedom of association. So where we seek to protect people from being excluded because of their religion, we equally recognise that if religion is to exist at all, religious bodies have to be able to maintain a chosen level of exclusivity to their premises or their composition or their services. So for instance, a religious school may admit students of many faiths, it may prefer students of only its own faith, but that discretion isn't viewed by other faiths, even those that might be excluded, as discriminatory because they understand and accept its existential importance to the existence of all faiths. Now that's a simple concept, but it's difficult to draft. And in choosing how to formulate exceptions for religious bodies under the bill that is now in draft form, we've adopted a broad approach informed by the exception that exists in section 82 of the Victorian legislation. The effect of that broad approach is to preserve essentially a status quo whereby a defined religious body can, in dealing with the exclusivity of its premises, its composition, its services, apply its own determination of the best application of its doctrines and beliefs, and it doesn't discriminate by acting in good faith on that basis. So, for example, in Victoria, it would not be discriminatory for an Islamic school to decline to employ Catholic teachers, or vice versa, or indeed for the same school to decline to employ an irreligious person. Now, just for the avoidance of any doubt, and as I've said in our consultations many times, it cannot be stressed enough that this type of exception in a Religious Discrimination Act applies only in respect of decisions made on matters of religious doctrine that pertain to people of different religious beliefs. So this bill does not affect the current exemptions that exist for religious bodies in other discrimination acts at either a state or Commonwealth level. It doesn't affect those types of actions that can be run, save for one issue with respect to freedom of expression. In all of the consultations that we've conducted, religious groups particularly have put a very strong view that the definition of religious body is very important to them because of the reasonable autonomy it provides an organisation that falls inside the ambit of that definition. And when we consulted, we said that we pay specific attention to religious hospitals and religious aged care providers. They were not in the bill at first instance, but they obviously serve very critical roles in the Australian society and economy. And I think a summary of what's become clear during the consultation process is that with these organisations, in their real-world operation, religious hospitals don't actually appear and haven't put to us that they make decisions about the admission of patients based on any given patient's religion or absence of religion. That's just not something that in practice they do. And they don't seek to do that. And likewise for aged care providers, with a few very small exceptions, they do not appear to consider religion or lack of religion before making a decision on whether or not to accommodate a person. But nevertheless, religious hospitals and aged care providers have indicated to us very strongly that similar to religious schools, the ability to take religion into account in staffing decisions was very important to them in maintaining the religious ethos of their organisation. And so they've reasonably sought an exception to the general prohibition of religious discrimination that would allow them to make staffing decisions in accordance with faith. Religious hospitals and aged care providers obviously themselves recognise that they've got competing objectives of providing access to health services and maintaining a faith-based identity, and that they have to be reconciled, and they seek to maintain a very balanced position, I think, with respect to those. I can say here that the bill that will ultimately be introduced shortly will have one significant change from its first draft, and that is that religious hospitals and aged care providers will be given protections equivalent to those given to other religious bodies in relation to the employment of staff. And while we talk about this balancing exercise between competing values, I can usefully say a few matters about the proposed Commonwealth Integrity Commission. Now, that is at its heart a very, very important balancing exercise. There is an obvious value in a powerful investigative body of broad jurisdiction that is properly designed and equipped to successfully investigate contravention of Commonwealth law amounting to corruption in the public sector. It's important because people will be brought to justice. It's important because it provides a standing deterrent to that behaviour. But that objective always has to be balanced. And it has to be balanced with a foundational goal of any liberal democracy, and that is to treat individuals with fairness and justice when their rights and reputation are at risk of serious deprivation by an adverse finding of criminality or corruption. That is the central balancing and critical balancing exercise. So as important as detecting and deterring corruption is to this government, you have to design laws to do that that will prevent injustice and unfairness to people investigated and accused by what is the overwhelming power of the state. And that is just completely foundational to what we all at least profess to believe in liberal democracies. And that balancing exercise between bringing people to justice and doing justice by people is not theoretical. And many, many times with bodies of this type, corruption and commission type bodies at a state level, they have fallen well and obviously short of long accepted standards of justice and fairness. There have been some very clear contraventions of even the most foundational right in the justice system, the right to be presumed not to have done something criminal in the eyes of the public and the government until it has been proven that you did. And one of the very first reports, which I just want to explain here today, because it never gets mentioned, but one of the very first reports I had to consider on becoming a State Attorney General was that of the then Parliamentary Inspector of the West Australian Corruption and Crime Commission, Mr. Malcolm McCusker QC. There are very few lawyers that I have ever seen better than Malcolm McCusker, or that I admire more. But at the time he was Parliamentary Inspector, and he was asked to scrutinise a report of the WA Corruption and Crime Commission, which had made a finding against a man, Mr. Allen. And the finding was that Mr. Allen had been engaged in misconduct by complying with the wishes of Brian Burke, notorious Brian Burke, who was then a lobbyist, by agreeing to appoint a particular planning officer to write a planning report on a development at Smith's Beach. Now, for anyone interested, Smith's Beach is a marvellous surfing spot just south of Yanchep, and as a tourist plug, I'd recommend everyone go there. Mr. Allen, unfortunately, is a much unhappier story. His career was utterly ruined by this finding, and I'm sure that his life was changed forever. Malcolm McCusker's assessment of the ultimate injustice done by the Commission and of the gross procedural unfairness is absolutely devastating reading. Relevant witnesses were not interviewed. Witnesses that were interviewed gave evidence which did not support serious adverse findings. Indeed, they negatived those findings. That exculpatory evidence was not mentioned in the CCC report. Other relevant witnesses were ignored, and had they been interviewed, they would have provided evidence further inconsistent with the findings. Contrary to all principles of fairness, inferences of wrongdoing were accepted when other reasonably available inferences were clearly open. Mr. Allen was the subject of a public hearing that he fairly described as being pilloried in public, and Mr. McCusker concluded that the delay between the public examination and the report was unacceptable and unfair to him. Mr. McCusker ultimately concluded that the CCC had not identified any evidence to support the finding of misconduct, and the CCC should publicly acknowledge that it was in error and apologise. I bet you there's one thing that would unite almost everyone in this room is that no one would have ever heard of this case or Mr. Allen. But that experience of Mr. Allen is not unique, and you can add to his name a long list of names of others: Murray Keir, Nick Greiner, Michael Gallagher, Margaret Cunneen. What happened to Margaret Cunneen was a disgrace, full stop. There was another remarkable case in WA where a Labor state minister was found to have engaged in a CCC report in inappropriate conduct. That was found to be not even a term used in the Act. And again, you would have never heard of that matter. And this is not to say, and I need to make clear, this is not to say that the problems, failures and shortcomings with state bodies have overwhelmed their utility or their desirability or the desire of the government to have a body of this type at a Commonwealth level. But we have to note, understand and be wide-eyed that there have been problems, they've been real, they've been serious and they've been multiple. I must say, one observation I've had in drafting around a future Commonwealth Integrity Commission is that some who advocate strongly for a Commonwealth body of this type seem to do so with this strange, uncritical tendency to apologism for these known failures that have occurred in state bodies. So rather than acknowledging and understanding the extent and nature of known failures as a means to avoid the injustices being repeated at a Commonwealth level, some prefer to explain the problems away or argue that they were somehow immaterial. There is this extraordinary paragraph in a report of the Australia Institute which seeks to deal with a very significant type of shortcoming that have been experienced, which is instances where someone has been subject to a finding of corruption, but the Commission investigation has then failed to secure a subsequent conviction for a relevant offence. Now, failing to secure a prosecution is a form of shortcoming, and it's a form of shortcoming that warrants very, very serious consideration. Why? Well, because it represents a situation where someone is burdened with all of the inevitable life-destroying repercussions of a finding of criminality that has not been tested against the centuries-old protections that individuals deserve and receive in courts. And that type of problem and its significance was succinctly described by the Acting Inspector General of the ICAT, Mr. John Nicholson, SC, when he said, "There should be no doubt the public perception of a finding that a person engaged in corrupt conduct amounts to a label as potent as any criminal label short of murder." So being labelled in this way is a very, very significant outcome. Now, this is how the Australia Institute, in one of their papers, explains away this known problem of adverse findings of a commission failing to secure a conviction for a relevant offence. They say, "This does not necessarily mean that the corrupt conduct did not occur, but that legally it did not constitute a proven criminal offence. It may also mean that the onus of proof required in a court was not met. The rules of evidence led to critical information being withheld from court, time limits on prosecution had lapsed, or the person under investigation," and I love this, "exploited a legal technicality." So the Australia Institute's response to this critical problem area of, and clearly exhibited in state-based commissions, is to essentially say, well, people are exploiting legal technicalities. Like, if it weren't for annoying little things like the burden of proof, the presumption of innocence, the rules of evidence, there'd be a perfect record between corruption findings and prosecutions and therefore no problem. Nothing to see here. But I find that utterly remarkable that it ever made its way into print. And I think it demonstrates none of the usual precautionary legal respect that you would have for due process that we would seriously expect in a debate on an issue as critical as this. I must say that there are some other very strange things in some part of the Australia Institute papers advocating for integrity commissions. In the same paper, the Australia Institute cite the WA-CCC Smiths Beast investigation as a good example of a successful investigation. Because even though the substantive prosecution from that report against Brian Burke failed, there was nevertheless a finding against him. Now, I find that an exceedingly generous assessment of that investigation, and of course it makes no mention of Mr. Allen. Like, he's been wiped from Corruption Commission history because he doesn't fit a certain sort of narrative. And in all these papers, there are other case studies in Australia Institute papers. One is into Sharif Khazal and one is into the Murray Kia matter. Now, the Khazal matter was the subject of a very strong criticism by the then acting ICAC inspector, who said that Khazal and Kelly, and this is his words, were unable to test the corrupt findings made against them in a court of law. The consequence is that each has been stigmatised and ashamed by a finding that has not been made and cannot be tested in an environment that has rules of evidence and procedures established over centuries to ensure a fair and impartial hearing to them and their opponents. Now, people can read the Australian Institute report for themselves, but the extraordinary response in their paper, in their case study, is to effectively say the inspector got it wrong. I find that remarkable. In the Kia matter, Mr. Kia made out a defence in court to a charge under Section 20 of the Public Interest Disclosure Act. He was found not guilty by a magistrate who found there was no element of revenge or payback or reprisal. The Australia Institute provides a case study of this and explains this failure by quoting the present ICAC inspector, in effect to saying the magistrate got it wrong. Now, I don't know precisely when statutory officers were able to declare court judgments wrong, but I find that, again, a very strangely uncritical approach, which is not at all wide-eyed about problems that we know have emerged and existed. In fact, I must say, I find that the case studies that I've just described such a defensive apologism of serious ICAC failures, I'd be interested to know who actually drafted them. But ironically, in a paper about transparency and integrity in the public sector, the Australia Institute does not make clear which individual on the committee authored the case studies, or indeed any part of the paper. But ultimately, the model advanced by the government tries to find the right balance between strength and caution. And in our model, the government, in its public sector division, the corruption of the proposed organisation proposed will not be able to make corrupt findings. Rather, in the public sector division, the organisation will be tasked with investigating matters and building briefs of evidence that are then sent to the Commonwealth DPP for prosecution in court. And as I've noted, there are many very good reasons for that type of approach. There is a very strangely uncritical approach at times by some people to integrity commissions, as if they're the only unmixed good in the history of law enforcement. That can't be true. In the Shadow Attorney's General addresses to this National Press Club, in advocating for the urgent need for a Commonwealth Integrity Commission, there was over 3,000 words and only one note of caution that I could find. It was a sentence where, in talking about a need for balance, it was said, "There are some well-publicised cases of individuals who feel their reputations have been unfairly damaged by appearance at state-based anti-corruption bodies. Some elements of the media have taken these cases and run with them in an attempt to prove a case against anti-corruption bodies completely. I don't see that is the lesson that is to be learnt from these kinds of cases." Now, I would strongly agree with Mark Dreyfus that these cases should not mean that there should not be an integrity commission at Commonwealth level. There clearly will be, and there should be. But equally, we don't actually learn the lessons from these cases if we characterise them as cases where people believed or felt their reputations were unfairly damaged. Reputation and lives have been unfairly damaged. That is just a matter of fact. Many people's lives have been damaged, actually, irretrievably and unfairly. And these and other failures are things that warrant very critical consideration so that we learn from them and in designing future bodies of this type, avoid those types of outcomes. That apologist approach to the known problems inherent in designing Commonwealth Integrity Commissions, I think, leads to drafts like that put into Parliament by the Independents and Greens in the 45th Parliament and reintroduced in a very similar form in the present Parliament. Those bills suffer from some very, very significant flaws. The scope of what can constitute corrupt conduct is unbelievably broad. Corrupt conduct can include something as minor as a disciplinary offence, or even behaviour that gives rise to reasonable grounds for dismissal. Even an irregularity that gives rise to disciplinary action under those bills could be considered corrupt conduct. There is also immense confusion and duplication regarding how the bill would operate with existing agencies like the Ombudsman. The Greens bill proposes that findings of public sector corruption could occur retrospectively as far back as 10 years, even where the matter was at the time a minor code of conduct breach dealt with previously by the appropriate agency and the person was no longer a public official. That type of unbelievably broad retrospectivity is just completely at odds with fundamental principles of the rule of law. In the Greens bill, the definition of employee and public official are so broad, it may even cover foreign governments if they provide some form of service to the Commonwealth, for example, foreign aid purposes. And also, as I've said, the Greens bill clearly allows for findings of corruption on public sector matters to be included in reports, things that are not tested in courts. There is no effort in the Greens bill to engage in caution or to mitigate known risks because they don't believe that the risks exist. Now, when the first Independence Bill was considered by the Legal and Constitutional Affairs Committee in April 2019, the committee recommended, I think quite correctly, that the bill should not pass Parliament. Labor members agreed entirely with that conclusion. Then, remarkably, Labor decided that they would vote for almost exactly the same bill in September 2019. And they said, while it may not yet be perfect, it's quite close to what Labor would do in government. Now, I think, honestly, a better approach than voting in September for design features that you thought were fundamentally wrong in April is to actually calmly and soberly consider the failures of commissions that we've seen at a state-based level, see what's caused problems, and think about design approaches cautiously. The first feature of cautious design that needs treatment is that at a state level, commissions can investigate known offences that have been on the statute books for decades or longer and have known meanings and boundaries. So public servants, of which there are a great number at the Commonwealth level, could readily know what constitutes offences against Commonwealth Criminal Code that relate to things like obtaining financial benefit by deception or an abuse of public office offence. But then at a state level, the difficulty arises because commissions very often also investigate new offences or standards of conduct which variously get called corruption or any other corrupt conduct or misconduct or serious misconduct or improper conduct. And what behaviour falls inside or outside those terms is just, as a matter of fact, simply less clear. Now, because there are already strong existing oversight measures in place for these less serious public sector misconduct, irregularity type matters, the government's cautionary approach in this area is that the Public Sector Integrity Division will focus on criminal corruption, while the Law Enforcement Integrity Division would continue to function with the jurisdiction very similar to what exists at the moment for ACLE. Now, in relation to the Public Sector Division, the offences will be set out in the draft bill, and they'll be clear, they'll be knowable, and they'll be known. And they'll include offences such as abuse of public office, bribery, fraud, money laundering, the things, of course, that we want to see never occur at a Commonwealth level. A second issue noted earlier is that commissions often generate reports of guilt against public sector workers not scrutinised by the courts, and that can have life-altering reputational consequences. The third issue arises that some commissions can generate reports based on public hearings, and even if a person is not the subject of an adverse finding in a report, the public hearing itself becomes, and very often is, a form of final punishment. Now, this is not to deny the important role for public hearings in appropriate circumstances, but they come with a very, very high risk to individual rights and otherwise accepted standards of justice. Again, the government's approach here is to deal with these issues by establishing that the role of the public sector division of an integrity commission at a Commonwealth level will be to establish evidence of criminality, and that it will then be required to assemble and provide that evidence to the prosecuting authority for it to be proved in court. So I hope that gives a bit of a summary of the cautionary, balanced approach that we're taking on this incredibly important issue. And I'll just draw this contribution to the Press Club to a close by talking about press freedoms. And I guess this is a final observation on balancing exercises. And it is a very difficult, complicated, delicate balancing exercises. Press freedom is self-evidently critical as a value in our liberal democracy, but equally it's never been absolute. And the right to publish material of many types has always been subject to other critical rights. The right to a fair and unprejudiced trial, the right not to be defamed, the right not to be vilified. There have always been balances with rights to privacy, including laws to protect the identity of children in legal proceedings, the identity of law enforcement and intelligence officers, and to protect victims and witnesses in criminal proceedings. Indeed, here's a fascinating balance. There is a very serious limitation on rights to publish contained in the Public Interest Disclosure Act at a Commonwealth level that is designed to protect the identity of whistleblowers. And we've obviously seen recently that there are very complicated issues that arise when one media outlet publishes the details of a person who considered their identity protected by an undertaking by another journalist. These are delicate, complicated issues. There are always balances to be struck, and many of those arise in the national security context. The media's right to know coalition has raised 6 central issues, and the balances that need to be struck on each of those separate issues is complicated and very unique to that individual issue. I'm sure there'll be questions on many of these issues, but I just wanted to focus very quickly on 2 of them. The first is with respect to whistleblowers. The present Public Interest Disclosure Act, which was passed in the dying days of the Gillard-Rudd government, has been described by the Federal Court as technical, obtuse and intractable. I must say, I find it almost impossible to read and understand. It is a very, very difficult piece of legislation. It was comprehensively reviewed. That's known as the Moss Review. That review provides a very strong blueprint for reform. I've gone through that. Our government will soon release our formal responses, and I might note that those responses are to the Moss recommendations, but in my observation there is a need to go further than those recommendations to actually ensure the Public Interest Disclosure Act, which defines when you are or are not a whistleblower, is actually clear and understandable to the people who need to use it. The other issue I wanted to touch on briefly is defamation. The process of reform in defamation is actually very, very well advanced, and there is a very significant milestone due on the last Friday of this month. In 2006, there were uniform defamation laws introduced, and that was seen as a major milestone. They don't achieve